Good morning, everybody. Hello. Welcome to Amanda Chadwick's webinar today on behalf of Peninsula Business Services, talking about maternity and paternity. This Monday morning, such a topic where straight away I think people, when we think about maternity and paternity leave or pay, when I'm dealing with employers, they sort of breathe a sigh and go, gosh, what a nightmare. And it doesn't have to be a nightmare. This is the point I'm going to make throughout this presentation. It is going to be slightly different to my other presentations because it's purely really factual, and we're going to use some case history, but I just want to point out at the very beginning, it doesn't always have to be a sad story, and we can help people back into work after maternity and also help people with antenatal appointments and paternity leave as well. So bear that in mind as I'm talking. Don't feel negative straight away when I start talking about it. So my first slide, okay, for anybody who doesn't know me and hasn't heard me speak before, my name's Amanda Chadwick. I work for Peninsula Business Services Limited, and we actually integrate ourselves within over 26,000 businesses throughout the UK, helping them with employment law, basic things like letter writing, everyday scenarios, everyday facts with employment law, health and safety, and also with our employee assistance program as well. So just to bear in mind that we do help over 26,000 people when I'm talking to you. Right, the facts, society factors. What's changed in the last, 15, 20 years? This is a really exciting part of my job, which I really love, is finding out the facts and finding out how society patterns affect what we write for our clients in employment law and how to protect them. We know the law's there for maternity and paternity. We know what the employee rights are, but what we try to do is try and protect the employer and managers and HR from incidences that can happen at work through not having the knowledge or forward thinking or being proactive within contracts, policies and procedures. So first of all, society factors. Okay, what's changed? Well, I can tell you what's changed is the age of somebody giving birth. What we have now, I think, if you saw my photograph at the beginning, I'm actually 45 this year. If I'd have gone for an interview even just a few years ago and sat in front of somebody, they may have looked at me and thought, and without being sexist, would have thought, maybe she's not going to have any more children anymore. And that's changed. Society's changed that view we have of people, because I don't know if you know, but you can have twins at 60 with fertility treatment. I personally couldn't think of anything worse, but that's the way things are going. You can actually, you meet people that are on their second and third marriage, they have a new partner, doesn't have any children, and then you find that one of your employees that you thought maybe wouldn't be having any more children suddenly starting a new family again with their new partner, maybe in their 40s or late 30s, and we're seeing that as well with employers and the changes that they're getting with their staff. So we have to take into consideration, we're thinking about maternity or paternity, is the society factors and the impact that it has on our clients or people that we're advising, and those changes have to be incorporated in their handbook. Role changes at home, and what we're also seeing is a really good legislation that's come through where we can actually, a mother can share her maternity leave with her partner, which what we're seeing is role changes. You see, what we'll have women that are earning more money than men now, so it's more lucrative for the female to go back to work and allow the male to have more time off at home to bring the child. So we're seeing more people, seeing more men attend the nursery and act as the mother role, whereas there's a role reversal there, which we didn't see back in the 70s, 80s or 90s. Also, the other thing that we're seeing is we're seeing more and more people keep the pregnancy a secret. We're seeing people wait for the first or second or even third scan and then advising their employer that they're pregnant. Now, this is very dangerous territory for our clients, because what we could have is somebody working within a company, you don't know that they're pregnant, and you could dismiss them, and you don't know that you're dismissing them and they're actually pregnant, and they can claim pregnancy discrimination. So what I would say straight away is that, we need to look at something in the contract there. So we need to look at terms and conditions in the contract. We need to look at things like we're looking at is delegation of responsibility. So my example there would be, if I was an employer, I'd be tempted to go on the internet to look at the policies and procedures that are available. I'll look at ACAS's maternity rights, which are spot on. I'd look at websites regarding maternity and paternity leave. And what I would actually do is I'd look at those rights, and maybe I might copy those rights in my handbook. The problem I've got with that is I'm copying employees' rights, and we're writing them down. Now, for anybody who's in HR here, you will know maternity and paternity pay usually changes in April, October. We just had a recent change with that and an uplift. And what you might do is you might copy what's already there. What I want to do is I know what the rights are, but I want to protect me as the manager, as the employer, and as HR by having a term and condition there that says that the employees have to let me know when they're pregnant, i.e. I work for you and I'm not very good at my job. I'm within the first year of working for you. I'm not very good at my job. As per your contract, hopefully, if it's written this way, there'll be a good probationary period and a good suitability clause in there, allowing you to dismiss me if I'm not suitable for my role. You do just that because I am not very good at the job, and as per that clause, you dismiss me. I then come back and I say the reason that you actually dismissed me was nothing to do with the fact that I wasn't good at my job. It was to do with the fact that I was pregnant. You now have to defend yourself as the employer, as the manager, as HR, to show that you did your job correctly and that you dismissed Amanda Chadwick fairly as per the probationary period. Now, the one term and condition that we have in our clients' handbooks is a term and condition that's delegating responsibility to the employee. And this is where we can actually clearly state that this dismissal was a fair dismissal. And what we're actually going to say is that when a female employee becomes pregnant, she lets us know written at the earliest stage possible so we can make the health and safety standards necessary for her to do her job. So what we're actually saying is we're not mind readers. We're quite often the manager, the employer and HR have other roles to do apart from seeking out somebody who's pregnant, dealing with everyday problems within work. They have other roles to do and quite often get swept away with those other roles. And if we had to worry about everybody that was pregnant or going on maternity, we'd be worried sick. So what we're doing here is we're saying, here's the handbook, sign for it on day one and make sure that you let us know when changes happen to your circumstances, such as health, such as pregnancy. And then when you let us know and you notify us in writing, then we will consider that. Until then, as far as we're concerned, unless you tell us otherwise, you're not pregnant. So when we make that dismissal, it's a fair dismissal. So knowing when somebody is pregnant, I would say delegate that responsibility and authority to your member of staff. And I'm not wrong in saying that we do treat people that are pregnant with kid gloves. We have to be very careful and take each step and cross the T and dot the I when it comes to things like redundancy, when it comes to things like job changes, when it comes to things like recruitment and the probationary period. We have to be extra careful with that. And remember, unless you can objectively justify it, and that's in only very exceptional circumstances, can we find out if somebody's pregnant when we take them on. So job changes and changes in the job and law, what we need to know is that when somebody's job changes, we need to consult with them and speak to them. Lifting and weights. The example I've given you there, and the reason I put that in there with maternity and paternity is, you're all listening to me now, but how many people actually know what is the recommended lifting for a woman when she's not pregnant? Question yourself. How many people know the answer to that question? How many people actually know what a woman should be lifting recommended when she's not pregnant? Well, I'll tell you now, it's 15 kilos, which isn't a lot. And so the next question I'm going to ask you is, what is the recommended lifting for a woman when she is pregnant? Question for you there. Do you have the answer? It's 0. You should be doing risk assessments, which brings me back to the point when I said knowing that somebody is pregnant. If you don't know somebody's pregnant and they haven't told you and they're keeping it a secret from you and it doesn't say anything in the contract that they have to let you know, we've got a risk issue here because we have health and safety problems. People might work in a factory where they're picking up stuff. They might be working with the elderly or people in care that, through no fault of their own, the elderly might lash out and damage that mother and the child. So we need to know when somebody's pregnant, which brings me back to the statement before. Let me know when you're pregnant, and then we can sit down with you, we can implement those many risk assessments, we can implement the health and safety standards we've already got in place, but also now we're complying with the law, and we know we're not going to dismiss you and make the mistake of a pregnancy-related discrimination case. So 15 kilos when a woman's not pregnant, that's for a healthy person with both arms, etc. And when somebody is pregnant, we're talking about, you know, a risk assessment and zero lifting. So I'm going to give you a couple of scenarios here, and I want to ask you these questions regarding pregnancy. So two people in a same-sex relationship, are they entitled to paternity leave? Yes, they are. Okay, so remember that. Also, another scenario, same company, factory scenario. This is me working within your business. You might have a little bit of chuckle about this one because it's right at the Jeremy Kyle moment, and this is a Jeremy Kyle story. I work for you, and I am actually married to an employee that works for you as well. And then what happens is the employee leaves, the employee and I, my husband and I, who work for you, actually, we separate, but we continue working for you. Now, whilst I'm working for you, I'm actually pregnant. I become pregnant with my husband's child just before we split up. But also at the same time, I then get a bit clicky with another man that works within your business. Are you keeping up with me here? It is definitely a Jeremy Kyle moment, this one. So let's recap. I work for you. My husband works for you. We separate, and I become pregnant just as we separate. I then get clicky with another man that works there, and he moves in with me, and then I give birth. Who is entitled to the paternity leave? Question for you. Mull that over. Who is entitled to the maternity leave? The husband whose name is on the birth certificate, or the man who's actively going to be involved in the bringing up of the child? If our client rang our advice line and asked for advice on this, and believe you me, we take over 3,000 calls a day, and many questions are very similar to this. We have a lot of Jeremy Kyle moments where we have to advise our clients. But here we go. The answer to this is what we would say to our client. For the cost of the 2 weeks, we would give both of them paternity leave to save any future friction or hassle that you might incur. So we would recommend that you give both of them maternity leave. So there's a couple of scenarios for you. As I said, this seminar is going to be quite factual, this webinar. So the basics, have policies and procedures in place. Some make, just to bear in mind, some companies listening to me today, it's a known fact, might give more benefits than what is expected, and some companies just give the standard. Whatever you do, get them written down and put them in your handbook. Put down your standards and expectations, written rules of what the guidelines are and how to follow them, i.e. let me know when you are pregnant, written at the earliest stage possible. When you're requesting part-time working, please put it in writing so we can consider the request. If you want to come back to work and you want flexible working, give the guidelines again on what they should do so it's clearly stated. We need to know written at the earliest stage possible on your return to work. And if somebody's requesting flexible or part-time working, again, the guidelines on how they do that so they know clearly what they should be expected. Create this paper trail, and this creates then our defence for you, our clients. You know, when you're actually when somebody's ringing you up and they're saying to you, I'd like to work part-time, I'd like to work flexible hours, I'd like compressed working, I'd like term time working, you know, what you need to do is consider yourself that you are a business, and you need to advise that employee that they need to apply in writing at the earliest stage. And then what you're going to do is respond in writing, and your communication is now not going to be verbal, it's communicating via writing and keeping a paper trail and defence. That is one thing that we recommend to all our clients. So let's start with paternity leave. Paternity leave is entitlement to the person who has the responsibility of the upbringing of the child, the biological father, the husband or the partner. This is also the case in same-sex relationships. So they have responsibility of bringing up that child. So we could have a scenario where somebody actually, just to go on another Jeremy Kyle moment, we are talking about maternity and paternity here. I can bring in a couple of those, can't I, today? So what we have is we have a gentleman that goes out, has a relationship with somebody, gets that lady pregnant, then somebody else. As long as they're contributing to the upbringing of that child, they're the biological father, they're on the birth certificate, for example, then they actually can have the paternity leave. They must have worked continuously for their employer for 26 weeks, ending with the 15th week before the baby is due, or notified of being matched with an adoptive child. That's for adoptive parents. they can either have 1 week or 2 weeks paid paternity leave, but they can't take it as odd days. Now, I do get some employers that do allow this, but I think it's easily managed when it's in chunks rather than bits and pieces. So we recommend, and I know the legislation recommends, that it is taken in 1 or 2 weeks. The payment for paternity leave has actually gone up to £136.78 per week. Take paternity leave within 56 days of the actual birth. Some people hold on to it. The first couple of weeks they hold on to it, but I think most people do take it within the first couple of weeks. But they can actually hold on to it as long as they're taking it before the 56th day of actual birth. Within the 56 days, sorry. Additional paternity leave, 20 weeks after the child is born and ended by the first birthday. So they need to be able to take that between that time. And to qualify for the additional paternity leave, they must do that in writing at least 8 weeks before the start date of the leave and state in the facts. And again, I like to see in the handbook a little bit of a statement that says paternity leave. And you might, for example, just say, the payment, for example. I wouldn't mention the payment in a handbook because, as we know, this changes quite frequently. So if you're writing down £136.78 in your handbook today, that's going to change. And this government is very quick at changing things. So I can't predict if it's going to change within the next 6 months or a year, or even in the next 4 weeks. There's suddenly a bulk up in the price of it and the payment of it. So I wouldn't write down the actual payment of it because that could change. What I would do is make a statement saying paternity leave as per the current statutory payments. Please refer to HR, please refer to your manager. And for those people there, the employers that don't really have an HR department or a manager, and if you're using us, ring ups, we always have the current statutory payments there. But what you might want to do is, look them up in a book just like me. And you might, and make sure that it is up to date and it's not saying 2012 or 2011 next to it. Make sure it's the current payments before you quote them to people. So, paternity leave, maternity leave and pay. I have the right to 52 weeks maternity leave. I can now share this with my partner, but again, we need terms and conditions surrounding this and how that is. And going forward, chunks, we're going to talk about the future legislation shortly regarding that and the shared maternity leave. What we're seeing is the role reversal, as I mentioned earlier on, and more people taking and sharing the maternity leave if, for example, the female is earning more than the male, or a same-sex partnerships. The person who's given birth to the child is actually earning more than the person that's going to act as take the paternity leave, for example. What have you got in your contract and what notification terms and conditions? Go back today after I finish with this webinar and actually go back and have a look what you actually have in place within your handbook. Have a look what the notifications are. Just check you haven't got the payments there and it's out of date, and make sure that your contractual terms are met. And just, keep yourself afresh of what maternity and paternity leave entitlement is, remembering that it does change quite frequently. Also, we can include keep in touch days. What we also have in some companies, I know Starbucks do this, and I think it's a really good idea, is that when somebody's given birth during their maternity leave, they have the entitlement to come back and earn a full day's pay, and it actually keeps them into the swing of things. And as I keep saying to everybody, it doesn't have to be a sad story. 52 weeks is a long time, but if we have keep in touch days after the childbirth, making sure that they have 2 weeks off because of health and safety reasons and purposes, obviously, we bring them back in for keep in touch days. It means it keeps them in the loop, and it's a good idea then to keep them abreast of the training changes within the department, because I know as a mother of 4 children that when you've given birth, quite often you do feel out of it. When you've given birth, you think things happen. You know yourself, if you've been off, or you're off on sick, or you're off on leave or holiday, you think in 2 weeks holiday that things do change within the company. Imagine if you've had 52 weeks off and then you return. Are the relationships you've had at work going to be the same? I know lots of companies that I work with have different ways of bringing back people into work, but I like the keep in touch days. I like the fact that they can earn up to 10 days full pay on top of their maternity pay and come in and keep in the loop, keep up to breast with the training, keep up their relationships, include them on staff days out as well if you want to. So paid reasonable time off for antenatal appointments. Always get this question asked. Are they entitled to time off? Yes, they are, but reasonable time off to attend antenatal appointments. And I always say to the people that I work with, you know your staff better than I do. You know what your staff are like. You know who you're dealing with, and you know who's taking the mickey. So you may ask if there's too many of them for the appointment card. You're quite in your rights to ask for that. So Maternity leave and pay continued. 26 ordinary maternity leave and then 26 additional maternity leave. That's my entitlement. Some people take less than that, but they must advise you 15 weeks before the expected week of childbirth. We do work with companies where the employees actually kept that a secret. They've absolutely kept it a secret that they're pregnant. And this brings me back to that term and condition right at the very beginning that says, let me know when you become pregnant at the early stage. And I can tell you from experience that when I'm dealing with a pregnant employee, they probably already know their rights before you do. They've already looked them up on the internet or in a book or contacted the benefits agency to find out what their entitlement is. And when they sit with you, it's just a matter of process. And they'll go, I already know what I'm entitled to, because we're all human at the end of the day. We need to know what we're doing with our money, how we're going to work out the mortgage, etc., our rent, our bills. So we'll probably already know what we're entitled to, but we'll sit in front of you and they just want it confirmed by their own manager, HR, or employer, what they are entitled to. And not only at that point, what you're having is a face-to-face meeting with your member of staff, and at that point you can implement your risk assessment. And what you're actually asking them is, are you working nights? Do you work alone? How's your pregnancy going? And you might have these regular meetings with them, so that now what you're doing is you're showing an interest in the pregnancy, but also that what we're doing there is we're getting buy-in off that member of staff. We're preventing tribunals, preventing problems by speaking to our employee and supporting that member of staff. This is where I'm saying it doesn't have to be a sad story. What we certainly don't want, we do not want a pregnancy discrimination case where somebody's feeling unhappy throughout the pregnancy, didn't think the employer was supportive, didn't implement risk assessments, didn't tell them what their rights were. That's why we get the buy-in. That's why we sit with them. That's why we have regular meetings. So in that letter, we want a confirmation of their pregnancy, that I am pregnant, the date of the expected delivery, a medical certificate, MAP B1 form, date of intended maternity leave, and no earlier than the 11th week before the expected date. That's what we want in the letter when they confirm it. Let's put that in writing, let them know what we want. And during the maternity leave, they actually accrue their normal holidays, so remember that as well, and normal terms and conditions. Right to return to old job and terms and conditions. I have the right as a pregnant lady when I'm actually having a baby to return to my old job. I know 52 weeks is a long time, but I have the right to return to my old job. I'm sorry, but statistics state that a lot of cases this doesn't happen because businesses change within the 52 weeks. So we have to offer them an alternative with the same terms and conditions. If they're unable to do the job, if they can't do the job, or they want to change the job, this is what I'm talking about here, is when somebody is pregnant and they come into work and they're poorly because of their pregnancy, or maybe, for example, they're in work and the job that they do is so dangerous that they actually can't do the job because of the job role itself, i.e. working with children that might be violent, working in conditions where they pick heavy stuff up. What you need to do as the employer is, and that's just examples I've given you there are other examples I could give you, but if they are unable to do the job because of the job, then we need to look at an alternative work for them, and it could be an office-based work. We need to keep the same terms and conditions in place, remembering, because it's not their fault that they can't do the job, it's the job itself. So alternative work to be offered, or we may actually have to, if there's no other alternative work as an employer, suspend them on full pay, not suspending because of a disciplinary action, but with suspension from their job on full pay to protect the mother and the unborn child because of the job role. I.e. this could be in the service industry, this could be lifting, as I said, and working with people that through no fault of their own might be violent, so working in the mental health sector. There's no other alternative work for them to do, those jobs are filled, so it might be a suspension on full pay. As I said, I reiterate, not because of disciplinary procedures. Again, it might be sickness, a lady might be pregnant, and I will say that we do get three types of pregnancy. We get the pregnancy where somebody plods along, we have no issues with them, and they actually, are never off work, they just plod along, this is a pregnancy, I can carry on doing my ordinary job. This is quite scary because this person might take on other roles and not, and not consider the health of their child. So we need to keep an eye on those people, but again, no time off, manage their pregnancy, an easy employee to put up with and to manage and support. The next employee may be somebody who, through no fault of their own, is very, very, very poor poorly throughout their pregnancy. And again, we need to monitor this under absenteeism, sickness, and again, treat this person with kid gloves. Don't make a decision quite rapidly and dismiss them because of sickness. We need to consider the sickness is related to pregnancy, and we might take this out of the Bradford factor when we're considering the point system. And then we have the third employee that really, we all have different pain thresholds, and it might moan about anything from tiredness to earache to hip joint dislocation to sore feet to sore toes. You know the person I'm talking about. And all the way through the pregnancy we have, sickness because they're maybe just acting a little bit mild, or it might be genuinely they have a low pain threshold. Again, kid gloves, manage this and speak to them about their sickness and be supportive. So breastfeeding. So another a subject that was asked about prior to this webinar today is breastfeeding and what the requirements are. The requirements really are mainly through health and safety. And if somebody is a breastfeeding mother at work, they need to notify the employer in writing that they're actually breastfeeding, and the employer has to provide a suitable place for expressing milk for them. This is most certainly not the toilets. So we're actually looking for a private office where people can't see in, where a chair is available for that mother, and where they can where they can express the milk for breastfeeding. So bear in mind that the employee, it's up to them to let you know that they're breastfeeding in writing, and you may want to put a term and condition in the employee handbook to advise them regarding breastfeeding and maternity. Or when you have that meeting with the employee, is that you say, if you are going to breastfeed and you want to express milk at work, you need to let us know in writing to give us the opportunity to provide you with a safe place, safe environment, which will not be the toilets, I reiterate, not the toilets, to breastfeed or to express. So maternity and redundancy. As I keep saying, 52 weeks is a long time. It may be that we have to be in a redundancy situation, and again, kid gloves, consult, and as per the normal redundancy practice, you have to keep people informed and offer them alternatives of work, just as you would the normal redundancy procedure. But any clients at the end of this webinar today, any people listening here, I'm not going to dwell on redundancy here today because we're going to do another webinar in the future on redundancy, and a section on that will be maternity and rights. It's all about consultation. It's about looking at other work and remembering that when there's a redundancy situation within the workplace and somebody is off pregnant or having a baby, off on maternity leave, don't forget about that employee. That's where we see the mistakes that are made, where the employer, HR manager has forgotten that somebody actually that should be in that redundancy pool or as part of that redundancy pool isn't kept in the loop. And that's where they fall down at redundancy, and then we get an unfair selection for redundancy case, or they're awarded a payout because of that. We haven't kept them informed because we've forgotten about them, and that's detrimental to somebody that's had a baby, forgetting about them. So make sure that you're aware of any person when you're looking at redundancy situations that's off sick or they're off on maternity leave when you're considering them. So, and remember, a lot can happen within 52 weeks of somebody being absent with maternity leave. Lots can happen. It may be the company changes because circumstances dictate it's out of their hands. And remember, Peninsula clients, at the end of this webinar today, ring us before you make any decision regarding redundancy, because we may come up with an alternative that can help you, i.e. a layoff or shortage of hours or other scenarios that you might not think of. Again, I thought I'd touch on here while we're on about maternity rights and family-friendly rights and paternity, is dependence leave. Again, I always just give people a little refresher on this. The law states that dependence leave is unpaid. The legislation says you don't have to pay it, but I meet a lot of employers that do pay dependence leave, and they do pay it. And then it's funny, years later they say, please can you help us change it? We don't want to pay it anymore. Everybody's taking it. And I would say that it's all about managing, it's all about monitoring your staff, and your staff, you know who's going to take the mickey, who's not. But I would say pay versus pay or no pay. So paying dependence leave or no pay versus each other, it's all about monitoring it. If you pay, it's about consistency. It's about paying everybody. If you don't pay, It's about not paying everybody. So it's about consistency here. And the scenario I'm going to give you is I'm a lady that works for you. I'm 45 this year. Keep telling you, just in case you want to send me a birthday card. It's in July. But, pay or no pay, I work for you. I'm 45 years of age. I've worked for you for 10 years. I'm never late. I'm never sick. And I'm a really good hard worker. And I phone in today and say that my daughter has got earache, so I won't be in work today. And then you pay me. But then you've got a 16-year-old person that works for you that's got a baby, and they've only been with within your employment for 2 days, and they ring in and say that their baby's got a bug. The likelihood is that you might not pay that person because they've been there for 2 days, but what you might have is an age discrimination case here because that person is 16. You've paid Amanda because she's been there for 10 years, and you might well say that to the 16-year-old person. So an age discrimination case. What we do, and I'm afraid it's human nature, is we treat some employees more favourable than others, and what we've got to remember to avoid tribunals or to prevent problems in the future is that we've got to be consistent within our decisions that we make with our staff, i.e., pay everybody, or we're not going to pay, we don't pay anybody. So again, consistency. Absenteeism, dependence leave, it falls into absenteeism, it falls into sickness, and it's got to be managed under sickness as well. And also dependence leave, again, it could be a pet. It also could be somebody that they care for, a dependent, and a very old case is a gentleman that has an elderly lady that lives next door to him. He takes time off to look after her. His employer sacks him, and it turns out at tribunal the elderly lady, the lady that lives next door to him, is an elderly lady that lives on her own. She has no point of contact with the outside world, no living relatives, and when he goes to tribunal, he tells the tribunal that. So a little, moral of the story is speak to your staff. Don't make a decision on the phone. Wait for them to return to work and then make the decision. So, changes in 2014, 2015. Interesting changes that are coming. Very interesting. And remember, they say they're going to make these changes, so be aware. I'm talking about changes that may happen. We don't like to say changes are definitely happening until we see them set certainly in stone. So extended rights for new parents. What are the new rights? Under the flexible parental leave system, parents will be able to share 50 weeks of leave between them after birth or adoption. Remember I mentioned that earlier on, the circumstances dictate that the person that's given birth might be earning more money than the other person, and they switch the shared maternity leave. So we're going to call this flexible parental leave system. The full amount of leave is for a year, but the birth mother, will have to take her 2 weeks compulsory maternity leave first. So that's why it's only 50 weeks. You might have thought, when I said that, why is it not 52? It's because the mother who has given birth for health and safety reasons has got to take 2 weeks off work. So the remaining 50 weeks can be shared. It can be broken down to small chunks and time, and can be taken alternately by each parent. So I might take a week, my husband might take the other week, and then I might take a week. But let's have, in your terms and conditions or in your handbook, to say that when this law comes in, that we need to update the handbook to say that with these flexible parental leave, that there is a process for requirements and terms and conditions on how you request it and how you notify it. It may be that you say, in line with our business needs, that we need you to take 2 weeks in one chunk rather than a week here, a week there. It might be a month. So we've got to wait for this to come out really to know the ins and outs of this. But most certainly, I want terms and conditions in the handbook to dictate how this would be taken. And again, a happy member of staff is a happy workforce and more productive as well. And not only that, I think this is quite positive, the alternate work, because what we're getting is we're getting a parent that's in work regularly and keeping up to date with all the things that are happening in work. The downside of this, it's going to be an absolute nightmare for the employer. Whereas in the past, what we could do when somebody's on maternity leave is we could get a temporary worker in to cover that maternity leave. It might be a little bit harder now if they're taking it in chunks at a time rather than in long pieces and like more months here and there and 6 months here and there rather than a week here and there, sporadic, sort of leave. The right to request flexible working hours will be made available to all employees, not just parents and carers. Flexible parental leave will be a nightmare for employers, as I said. It's about the planning, sporadic, and it's an in and out situation. Also, when I think about flexible working, off on a tangent here with the term flexible working and somebody's right to request flexible working, which is separate to this, you know, there's all sorts of flexible working. And again, the right to request it in writing, flexible working, i.e. the examples of that are compressed hours, term working, part-time working, swapping shifts. There's all sorts of different aspects of flexible working or part-time working. It's not just as we used to think, oh, I'd like to be part-time, and you think they're cutting their hours down. There's ways of managing it now. It might be weekend work. It might be a shift that other people don't like doing, that they say, well, I'll rather do that than have it split over several days. Again, anybody listening at the end of this, when we look at flexible working, speak to us if you, because we have lots of different suggestions to make it more attractive to a business. Planned implementation dates for all of this is 2015, except the flexible working part, which is expected to be in 2014. Again, changes in 2014 and 15. Adoptive leave changes. The current qualifying period required to be eligible for adoptive leave will be removed, so employees will be entitled to take adoptive leave from day one of employment. Currently, employees need 26 weeks service at the point they are matched with a child to be entitled to adoptive leave. Antenatal appointments. Fathers will have a right to unpaid time off to attend 2 antenatal appointments. Bearing in mind this is the standard minimum, we do find in other companies that some companies allowing fathers to take the antenatal appointments, every single one that they go with their partner. So it's really clearly what's defined in your handbook that you need to look at. Surrogacy. Intended parents of a child born through a surrogacy arrangement who meet the criteria to apply for a parental order will be eligible for statutory adoptive leave and pay if they meet the qualifying criteria, and for flexible parental leave and pay if they meet the qualifying criteria. They will also be eligible for unpaid time off, again, to attend 2 antenatal appointments. Again, these changes haven't happened yet. They're coming in 2014 and 2015. I have to bear in mind I only have a maximum of 35 to 45 minutes for these webinars because attention span is quite bad. I'm giving you a quick overview here on changes that are happening and maternity and paternity. And remember, you know, I can actually have these slides forwarded to you if you need to see them. So my name is Amanda Chadwick. I work for Peninsula Business Services. As you know, we work alongside and inside over 26,000 companies. If you're one of those companies listening at the end of this webinar today, you have the benefit of our experience in writing your letters and also advising you and writing your policies and procedures and giving you the bang up to date. You also have the benefit of our Peninsula app and also the webinars that we host, our HR online service if you've subscribed to that, and also our employee assistance program, which helps people with stress, depression, and also counselling, etc. Yeah, I'm giving you a quick overview here today. And also our health and safety services. If you're one of those people that are listening at the end of this webinar today and you don't benefit from our services and you're thinking maybe that you would like some help, you may contact me at amanda@peninsula-uk.com. The emails come to me personally and I respond personally. It might take me a couple of days, but I do respond personally. If any of you are listening to my webinar today, which was a very quick webinar on maternity and paternity rights, and you'd like to listen to another webinar, or you'd like to have a webinar for your clients, we host them free for you. But also, if you'd like to have a one-to-one seminar, which I host on a regular basis for an association, a federation, or a group of businesses that you deal with, if you're an accountant and you think you'd like me to come and present to you, please contact me at free@peninsula-uk.com. Again, I respond personally to all the emails that I receive. I hope you enjoyed this webinar today. We will be contacting you shortly just to see if you did. And thank you for listening to me today. If you do have any questions, please forward those again to Amanda@peninsula-uk.com. Thank you very much and speak to you again soon. Bye-bye.